So I will start with a known fact and an interesting fact that, as we know, Nigeria has been grey listed by the Financial Action Task Force, and they found deficiencies in, our anti-money laundering, I'll just call it AML, CFT, proliferation financing, just to use the acronyms to make it shorter. And because of that, of course, there's heightened regulation and heightened scrutiny in, Nigeria's AML, CFT regime and policy. As legal practitioners, of course, as our role, we represent all sorts of clients, transactions. The legal profession has been identified as one of the key risks, one of the risk areas where, we need to ensure that, there's additional scrutiny, enhanced due diligence, etc. The grey listing was done in 2023. Before that, there was a 2022 Anti-Money Laundering Act, which brought in, new innovation and, additional rules and regulations for anti-money laundering, which was a good development. Unfortunately, Nigeria still got grey listed, and of course, it brought bodies like the NFI, EFCC, and the federal government in general to, look deeper and scrutinize these things deeper. So definitely, as a law firm, we, under the 2022 Act that I've just mentioned, are identified as designated non-financial businesses and professions. And in that instance, we have to register. We're mandated to register with SCOMO, that's the Special Control Unit, in charge of money laundering under the AFCC. And once we do that registration, of course, we have to file returns, suspicious transaction reports, currency transaction reports, and the like. I will not be given a full picture if I don't mention that, of course, as lawyers, we all know that we have the client-lawyer confidentiality concerns. And from the very beginning of the AML, CFT regime, we've had our body, that's the Nigerian Bar Association, push back a little about the applicability of this, not that we do not respect AML, CFT and the need to do and undertake, customer due diligence, enhanced due diligence, depending on the risk profile, risk-based compliance. But at the same time, we have to balance that against the confidentiality obligations we have towards our clients as lawyers. So in this instance, historically, there's been a lot of pushback, even, decided cases where lawyers were able to escape the formal reporting, as it were. Record keeping, no, because that's essential. But with the 2022 Act, that all changed, and with our designation as, non-financial businesses and professions. So we do have to render those returns, etc. But I must say that MBA is still running, trying to protect in the bid to continue to protect our clients and the clients, lawyer relationship and confidentiality. A committee has been set up by our regulatory body, that's the self-regulatory organization, the Nigerian Bar Association. So there's a money laundering committee that has been set up, and that is fully functional. They're bringing up policies, procedures, templates for returns, etc., because we feel like as lawyers, and we have to maintain the sanctity of our profession while we uphold AML, CFT, requirements. We also still need to protect our clients. So it's ongoing, it's parallel. But as you know, for a lot of us lawyers that work for financial institutions, for instance, it's mandatory if we, for example, want to be signed up or retained. One of the first things they would ask us is for our SCOMO registration. So whether we like it or not, it's something that we need to do. We need to comply and continue to comply. So in a nutshell, I don't want to go on for too long. We have to comply, and that's how lawyers, law firms, Lexworth, my organization being one of them, help in this fight against anti-money laundering, the countering terrorist financing, and proliferation financing as well.